We have come to the final stage of our 2017 Moot Court. I'm happy to see so many of you here, full of excitement, who will actually now win this year's competition. It's either Kenya or the Ukraine.
We are hearing today the case of the prosecutor versus Mr. Nuremberg, and we start, of course, first with the presentation of the prosecution case, and I give you the floor.
Good afternoon, Mr. President, your honors. May it please the court. My name is Anastasia Malenko, and this is a great honor for me to appear before this court on behalf of the prosecution. During the next 25 minutes, I will cover three following issues. First of all, the present case is admissible under Article 17, Clause 1 of the Rome Statute. Secondly, evidence obtained through torture may be admissible before the ICC. And thirdly, there are substantial grounds to believe that Mr. Nuremberg is individually criminally responsible for committing war crimes and crimes against humanity. This trial is about violence and misery, about thousands of innocent victims, and crimes characterized either by their seriousness and savagery, or by their magnitude, or by the fact that they were a link in a deliberately pursued policy against civilian population, or that they were a part of a system designed to spread terror around the country. This trial is the last resort to maintain justice. In that regard, and with your permission, I will proceed with our first argument concerning admissibility of the case at hand. Article 17, Clause 1 of the Rome Statute imposes three tests of admissibility, namely the complementarity, double jeopardy, and gravity tests. Since defense has challenged only two tests, the prosecution submits that this case is admissible since complementarity test is satisfied, and secondly, this case is of sufficient gravity to be heard by this court. Within the course of the first submission, the prosecution claimed that the principle of complementarity ensures that states' sovereign right to try cases over their territory would not be encroached upon. Therefore, the ICC can take any measures in response to the crime at hand only in case of failure of state to act in response of the crime, or that there were a finding that the state is unwilling or unable to carry out investigation in response to the crime. Thus, this is a position of the prosecutor that there is no state with jurisdiction over the case that is acting or has acted in relation to such case. Notwithstanding the fact that term inaction is not clearly defined in the Rome Statute, it was revealed in the February's decision in Lubanga case, where it was stated that even issuance of warrant of arrest without reference to concrete crimes cannot be regarded as active position of a state in response to the crime at hand. Even though the Commission of Inquiry can be established in accordance with domestic procedure, its functions are limited by nature of this function, since it is a non-judicial, fact-finding body aiming to investigate a situation. From the facts of the present case, it can be stated that national authorities still remain inactive in response to the crime, and let alone the prosecution of the perpetrator. The only actions taken by the national authorities were removal of Mr. Nuremberg from office on 14th January 2016. However, Your Honors, in February 2016, such commission made recommendation that must be brought light into further consideration and investigation of the crimes alleged by the Mr. Nuremberg. However, as to August 2016, there were no investigation conducted, and it was explicitly stated in the fact. Yes, Your Honor, your question.
Just before you go on, you state that the Commission of Inquiry was a non-official body. does that take away from the significance of its interviewing witnesses, collecting evidence, and making recommendations? Is that not a step by the state to investigate within the meaning of Article 17?
Indeed, Your Honor. However, it must be stated that upon the recommendation of the Commission of Inquiry, there were charges only about the excessive use of orders of the Mr. Naberry in response to the crime of the directly attack against civilians. However, the crime of outrage upon personal dignity, as well as the crime of enforced disappearance, were not addressed by this recommendation. Therefore, we cannot state that such commission actually revealed the situation in the Federal Republic of Nabu clearly.
And in respect of the dismissal or removal of Mr. Naberry from his position as Deputy Minister of Defense, would you agree with me that that's a step that removes potential immunity from prosecution or investigation?
Your Honor, in this respect, we can state that, as it was respectively submitted earlier, that removal of Mr. Naberry from a state was acted and conducted in February 14. However, in the February 2016, the Commission of Inquiry made their recommendation, and they were brought in order to conduct investigation and brought the light in their investigation in the territory of Federal Republic of Nabu. However, the national authorities actually refused for such actions.
Just one more question, then I'll let you go back to your submissions. The facts suggest that there are 288 persons that were arrested during the attack on the drug cartels that are being interrogated. Is it not also a step that is being taken to collect evidence from those individuals about the potential crimes that took place during the period of, what is it, February?
Exactly, Your Honor, it cannot be regarded as a step. However, in this case, we refer to the period of time within which such actions were conducted. Actually, we may refer to the situation in Georgia, for example, where it was also a period of 6 months where the OTP decided to conduct investigation, where there were now active steps into the investigation situation, and this state was remained inactive following their decision of the OTP. And in this response, we also state that 6 months is a significant period of time which maintained that their national authorities had to conduct an investigation, or at least, according to Article 18 of the Rome Statute, to inform the Office of the Prosecutor about any conduct, even secret conduct, which is actually maintained in the territory of their country.
What period would you say would be reasonable, short of 6 months, for the state of Nabu to have commenced an investigation?
Your Honor, the Rome Statute, as well as the rules of procedure and evidence and jurisprudence of the ICC, cannot provide us with their concrete period of time within which investigation must be conducted. However, we should refer to the analysis on a case-by-case basis. In a specific case, we understand that Mr. Naberry was charged with the crimes against humanity as well as the war crimes of committing outrage upon personal dignity and intentionally directing attacks against civilian population. This is a reason why such commission and that recommendation must be taken into account, and investigation must be conducted for such not significant period of time. Thank you, Your Honors. And in respect to the gravity test, which must be assessed in conjunction with the complementarity, we still claim that in this concrete case, we shall apply the test which was provided in Lubanga judgment. Following these statements, the gravity threshold would be satisfied when, firstly, the conduct is systematic or large scale, and due consideration also must be taken social alarm caused to the international community. Secondly, it can be conducted only when the perpetrator is among the most senior leaders and the most responsible for commitment of the crime at hand. And the third criterion which must be elaborated is the role played by such state entities, organizations, or armed groups in the overall commission of the crime must be deemed important. And from the facts of the case, it must be stated that crimes alleged are of systematic and widespread nature. Mr. Naberry acting as a deputy minister of defense and the founder of a secret group named Pender, which was from the ex-police officers and national security agents, actually perpetrated in atrocities in accordance with the new security agent strategy. And this can be stated that Mr. Nuremberg indeed was among the most senior leaders, since he was the Minister of Defense and he actually was the creator of such group who carried out execution of his orders. And it can be also inferred that the role played by Pender organization in the overall commission of the crime also deemed important, since attacks directed by the perpetrator was ordered by the Mr. Nuremberg to execute, and within such execution, the crime would not be actually committed in the territory of Federal Republic of Nabu. Therefore, since 2/3 admissibility test is satisfied, prosecution submits that this case can be actually admitted and admissible by the court. If your honors have no further question, I will proceed with my second argument concerning the admissibility of evidence obtained through torture. According to Article 69, Clause 7, the ICC has discretion to decide on the matter of admissibility of evidence obtained through torture. The prosecutor submits that, first of all, evidence were obtained without violation of internationally recognized human rights, and secondly, prerequisites for inadmissibility of evidence represented in Article 69, Clause 7.ab were not fulfilled. Exclusionary rule of Article 69, Clause 7 can only be triggered when there is a violation of the Rome Statute or internationally recognized human rights. Therefore, prosecution claimed that there were no violation of the internationally recognized human rights, since, according to Article 1 of the United Nations Convention Against Torture, the act of torture must be committed with complicity of official, with a certain purpose and intentionally. Indeed, your honors, we do not contest that evidence were obtained through beatings and electrical torture. We also raise no objection according to the fact that their interrogation were actually intentionally, since the reason of such interrogation were to obtain information about whereabouts of their drug cartels members who were kidnapped. However, your honor, according to international human rights law, act of torture recognized as the base element the complicity of the official, which from the facts cannot be revealed, since unnamed people actually interrogated Adjutant Mendoza in order to reveal information about whereabouts. And since defense proved that unnamed people from video acted in their official capacity, prosecution claimed that there were no act of torture, as there were no violation of internationally recognized human rights. And therefore, it brings me to submission where it will be assessed the prerequisites of the admissibility of evidence. Therefore, prosecutors submit that, first of all, violation did not cause substantial doubt on reliability of evidence, and secondly, admission of such evidence would not be antithetical to and would not seriously damage the integrity of the proceedings. Regarding reliability of evidence must be assessed the Alexowski test, namely the nature, trustfulness, and trustworthiness of evidence obtained through such violation. Applying these tests, trustfulness and trustworthiness of the evidence are present, even so they were obtained not voluntarily. From the facts, we can state that Adjutant Mendoza revealed information about the link of Mr. Nuremberg to secret group Pender. Therefore, we claim that it was not information which actually was requested by the interrogators in order to obtain their information about whereabouts. And from the statement of the facts, it was actually stated and explicitly that Mr. Nuremberg personally instructed Adjutant Mendoza to destroy all evidence concerning the link of the Mr. Nuremberg to the secret group, and it was only information which he could share through his status and information which he could reveal. Therefore, there is no credible evidence that Mr. Nuremberg actually, that Adjutant Mendoza actually suffered, and during such suffering he revealed unreliable statement.
I would like to intervene and ask a question. My question is whether prosecutor office does continue investigations now?
Your Honor, it was not explicitly stated in the facts. However, we still claim that as for now, for this moment, investigations were not conducted, and therefore, Office of the Prosecutor now concerning such an investigation and prosecution. And concerning the second part of the admissibility evidence, it must be stated that the court should preserve its moral authority and under the theory of integrity. In that regard, the court shall use its discretion to strike the balance between the interest of due process and effective law enforcement. Following the reasoning in the Prosecutor versus Burdanin case, it would be inappropriate to exclude relevant evidence only for procedural considerations. It would constitute a dangerous obstacle to the administration of justice. Therefore, Your Honors, in case this court finds that evidence were obtained through violation, it therefore must be excluded from admissibility. We lose any proofs of connection with Mr. Nuremberg to the cruel commitment of the crime of enforced disappearance.
Let me just ask you this question. Forget about the legal definition of torture, but let's just accept the fact that what happened to Mr. Mendoza was in fact torture or torture-like in terms of the physical acts against him that caused him to make the statements. If we were to consider this evidence for the purpose of confirmation, would you agree that this is the only evidence linking Mr. Bandera to the Panthera group and the abduction of the drug barons? Yes?
Indeed, Your Honor.
And given that admission, if at the trial there was no further evidence linking him to that group, would you say that it would be safe to convict only on the evidence of this video?
Your Honor, from the facts of the case, we can only state that video with interrogation of the adjutant Mendoza, the only credible evidence of connection with Mr. Nuremberg, since there were only one statement in the fact that Mr. Nuremberg actually created such group and tasked it with execution of any military operations. However, point of evidence was contested before this court, and we understand that if we lose this evidence, which is in the position of the prosecutors, the only relevant evidence for the commission of the Mr. Nuremberg's crime of enforced disappearance, that he will not be guilty for this crime, and what we should do with the victims of such crime in that case. Therefore, we invite this court to understand and to reveal that admission of such evidence would be, for the procedural consideration and for the integrity theory, very important and significant step. If you others have no further question, according to my second submission, I will move to the third submission, concerning that Mr. Nuremberg is individually criminally responsible for committing certain war crimes and crime against humanity. Regarding commission of the crimes against humanity, prosecutors state that Mr. Nuremberg is individually criminally responsible for the crime of enforced disappearance of persons prescribed by Article 7, Clause 1I of the Rome Statute. Following the meaning of Article 1 of the International Convention for the Protection of All Persons from Enforced Disappearance, there cannot be any justification for enforced disappearance, even in case of state of war or internal political instability. To prove that alleged actions constitute a crime of enforced disappearance, it must be established that the accused intentionally abducted one or more person or refused to give information about the whereabouts of the victims. Furthermore, crime of enforced disappearance must be carried out by support or acquiescence by a state or organization. The prosecution submits that contextual element is met, since the conduct was committed as a part of a spread and systematic attack which is required by all crimes against humanity. They occurred against a civilian population and with knowledge of such attack. According to Kordic and Kertic,
May I shortly?
Yes, Your Honor.
May I shortly? We are now talking about the enforced disappearance. Is that correct?
Yes, Your Honor.
Yes. And what would you say? Are the drug barons? Are they civilians? When we look at Article 7.
If we regard that drug barons are civilians, therefore we cannot claim that any attack and armed conflict actually exists in this case, and therefore the charge of the war crimes will be dismissed. And we invite this court to refer to the statement in the facts where it was stated that such drug cartels had a lot of military ammunition and military units. Therefore, we cannot state that they, in the context of an armed conflict which is not international character, cannot be regarded as a party of the conflict, which is an armed organization. Armed organized group participating in such attack.
But wouldn't we need civilians as victims in that effect for Article 7?
I'm sorry, Your Honor, may you paraphrase? I just hadn't heard.
You know, you're saying that we are not discussing the enforced disappearance of these drug barons. And wouldn't they have to be civilians according to the law?
According to the international humanitarian law, civilians are all persons who did not take direct part in hostilities and who cannot be the party of the armed conflict. Actually, who is not involved in the conduction of an armed conflict. However, from the facts, we can't say that drug barons were involved in such armed conflict within their meaning of their non-international armed conflict.
I think we can come back to that when you discuss Article 8 and the armed conflict, and perhaps we can have then further questions. Another question would be, you have said that it is widespread or systematic. What is it, widespread and or systematic?
Your Honor, according to Kordich and Kerzich judgment, the expression widespread or systematic exclude random or isolated acts of violence, and widespread refers to the large-scale nature of the attack and number of victims, whereas systematic connotate to the organized nature of the acts of violence and improbability of their random occurrence.
Just to make a point, we have 15 people abducted, and would you say this is widespread?
Your Honor, it was stated in the jurisprudence of the ICCPR that even a single act of enforced disappearance due to the conduct of a widespread and systematic attack throughout such country can be regarded as a crime of enforced disappearance and therefore as a crime against humanity.
Thank you.
Thank you, Your Honors. Therefore, I will proceed with the argument that perpetrator committed a crime of intentionally directing attacks against civilian population set out by Article 8, Clause E-Y of the Rome Statute. Following the reasoning of the appeal chamber in Strugar case, it was stipulated that provisions that contained in Article 13, Clause 2 of the Additional Protocol 2 have attained a customary international law status, and obligation to protect civilians is of sacred character. Therefore, prohibition of any attacks against civilian population is of absolute nature. According to Article 8, Clause 2, EY of the Elements of Crimes, alleged actions may be qualified as a crime of intentionally directing attacks against civilians in case, firstly, the perpetrator intentionally directed attack against civilian population as such, or certain individuals not taking direct part in hostilities, and secondly, that the accused knew that conduct occurred in the context of an armed conflict not of an international character. Criteria which must be taken into account to determine the existence of an attack directed against civilians are the means and methods used in the course of the attack, the status of victims, and their number. Given that the civil population of Iran, including farmers and countrymen, were forcibly involved in commission of the illegal drug trafficking, Mr. Naberi was aware of the fact that they were actually participating in such hostilities, since they cannot be distinguished because they were not dressed as such and used any uniforms. Therefore, Mr. Naberi stated that every person who collaborates or was even forced to collaborate with the drug cartels is our enemy. Thus, when ordering military units to attack the bases of the drug cartels, the perpetrator knew that the civilian population would suffer.
What evidence is there that the civilian population did in fact suffer? The evidence is that there were armed clashes between the military and the paramilitaries from the drug cartels, that 4,760 people died. But there's no indication as to whether those were the armed paramilitaries or civilians.
Indeed, Your Honor. I understand your question correctly, and it was stated in the fact that it could not be possible to distinguish between civilians and their members of the drug cartels. However, the principle of distinguishing civilians is also attain their status of customary international law, and therefore must be applied both in the international armed conflict and non-international armed conflict. However, Mr. Naberi failed to satisfy this criteria and to follow such principle, and directed military units to drug cartel members, knowing that the civil population of such country actually can be participating in such drug cartels.
But I would expect that the defense will raise the fact that they could all have been military, and therefore the benefit of the doubt goes to them, and there were no civilians killed. What do you say to that?
International humanitarian law provides with the definition that even if the civilian population was forced to collaborate and to take part in their hostility, they cannot be regarded as combatants within the meaning of such word. Your Honor, I see that I am lack of time. May I briefly wrap up my last argument of the outrage upon personal dignity? Prosecutors submit that actions committed by the accused amounts to the crime of outrage upon personal dignity, since in Alexovsky and Kunaraj it was explicitly stated that prohibition of the crime of outrage upon personal dignity constitute a category of the broader concept of inhuman treatment. And dead persons also must be victims of the crime of outrage upon personal dignity, notwithstanding the fact that they should not be aware of the likelihood of the... May I last my submission, Your Honor?
Please. Shortly, because I would like to address you also shortly.
Sure. It was stated that dead persons could be victims of such offenses since they need not personally be aware of the existence of the humiliation or degradation or other violation upon their personal dignity. Therefore, posing in the photos with the dead troops cannot be regarded as a commission of the outrage upon personal dignity, since Mr. Naberi, as the Deputy Minister of Defense, shared personally on his social platform account, having 50,000 followers, the photos which indicate the posing with the dead bodies. It cannot be regarded as something which is not attain the status of their violation under this article.
Yeah, I think it would prolong too much if we would ask the questions that we have. Perhaps we have the possibility when there is the rejoinder later on. Thank you very much for the moment.
Thank you, Your Honors. May it please the Court.
And I give now the floor to the defense.
Mr. President, Your Excellencies, may it please the Court, my name is Catherine Pender. With me is Lisa Owino, appearing on behalf of the defense. This court has allocated 25 minutes to us, of which I will use the first 10 minutes to talk about the preliminary issues before this court, and the remaining 15 minutes will be used by my co-counsel to talk about whether the alleged actions amount to war crimes and crimes against humanity in the Rome Statute. With the permission of the court, before getting into the specific issues in contention before this court, I would like to assert that this court has the jurisdiction to listen to this case pursuant to Article 12 of the Rome Statute. And with the permission of the court, I'd now like to begin on the first issue on whether the investigation that was conducted in FRN amounts to an investigation under Article 17 of the Rome Statute, and whether the 6-month gap incurred in conducting the investigations amounts to an unjustified delay. Your Excellencies, Article 31 of the Vienna Convention states that every law should be interpreted according to its ordinary meaning, and Your Excellencies, investigations, when interpreted in its ordinary meaning, simply means that it's a fact-finding mechanism, Your Excellency. And in the case before us, the Commission of Inquiry, though not a judicial body, the defense acknowledges that is a fact-finding mechanism that has been established to figure out whether Mr. Naberi used his powers in excess. The prosecution has also stated that the Commission of Inquiry is not conducting investigations on the same case before this court. However, Your Excellency, The Office of the Prosecutor stated that it does not have to be exactly the same charges as the ones in the ICC, but should be substantially similar charges, Your Excellency. And in the case before us, it can be seen that it is not exactly the same charges that are being investigated by the Commission of Inquiry, but the charges that are being investigated by the Commission of Inquiry are substantially similar to the ones in these proceedings, therefore fulfilling the same case test under the investigations being conducted. Your Excellencies, the prosecution has also stated that the state of FRN has not taken any steps since the Commission of Inquiry tabled its report to the government and stated that the 6 months gap amounted to an unjustified delay. However, Your Excellency, the defense is of a contrary opinion and would like to prove to this court reasons as to why the 6 months gap does not amount to an unjustified delay. This court has determined the issue on whether there has been an unjustified delay in 2 cases. The first case is in the case of Prosecutor versus Al-Senussi, where the court had to make a determination of 18 months, and in the case of Prosecutor versus Simon Bagbo, where the court had to make a determination of 20 months. And the defense acknowledges that this court has not pronounced itself on what is the stand regarding a gap of 6 months delay. We would therefore like to make an analysis and show the comparison between the 2 cases, in which in one case on the 18 months the court stated that there was no unjustified delay, and in the case of Simon Bagbo, where the court stated that 20 months amounted to an unjustified delay. Your Excellencies, I quote this court in the case of Prosecutor versus Al-Senussi under paragraph 223, where it was stated that a determination of an unjustified delay cannot be made against abstract justice. However, such a determination should be made by looking at the specific circumstances in the case and by looking at whether the investigations are concrete, tangible, and progressive. And in that case, Your Excellency, the fact that their investigations were progressive, it was stated that the 18 months could not amount to an unjustified delay.
I have a question. I would like to return to Article 17. What does it mean? What is your understanding? The case is being investigated or prosecuted. What is your interpretation?
Your Excellency, according to Article 17(1)(a) of the Rome Statute, the defense understands that if a case is being investigated, in that whether there are steps that are being taken to ascertain whether the accused person is liable for the alleged offenses, then an investigation is going on and is being prosecuted, Your Excellency. It's in its ordinary meaning that the judicial bodies are conducting investigations, and the defense in this case is relying on the fact that there is an investigation in the state of FRN, and the 6th gap in that investigation does not amount to an unjustified delay, so that this court can come to the conclusion that the state of FRN is unwilling to conduct their investigations.
May I shortly? I think the facts show that there has no investigation initiated at all at the moment. Wouldn't you say, when you yourself admitted, so to speak, that the inquisition of inquiry, the Commission of Inquiry, really showed and it was a fact-finding instance and amounted to the charges that later on were put against Mr. Naberi? So they made a recommendation to start investigations. And wouldn't you say, before this backdrop, that starting an investigation is simply a formal act which has not been undertaken until now?
Your Excellency, the defense acknowledges once more that since the investigations by the Commission of Inquiry were tabled to the government, nothing has been done, or the government has not yet responded to that investigation. However, Your Excellency, the defense would like this court to look at it not as an unwillingness on the side of the state, but to look at it as slow progression in conducting their investigations. Thank you, Your Excellency. I'd like to proceed to my second argument because I have exhausted my first argument. And quickly, I'd like to move on whether the evidence that has been obtained through torture, it can be admitted before this court. Your Excellency, the defense notes that Article 69(7) of the Rome Statute does not mean that evidence that has been obtained through torture should automatically be excluded. And the defense acknowledges that evidence that has been illegally obtained, such as in this instance through torture, can be excluded only if the violation casts substantial doubt on the reliability of the evidence, and only if admitting such evidence would damage the integrity of these proceedings and would be antithetical to these proceedings. Your Excellency, the prosecution stated that in order to determine whether evidence is reliable, the court should look at the nature, the trustworthiness, and the truthfulness of the nature. However, Your Excellency, the prosecution also forgot to take note of the fact that in the case of Prosecutor versus Lubanga, paragraph 28, it was stated that in order to make a determination as to whether evidence is reliable or not, the court should look at not only the content of the evidence, but also the context under which the evidence was obtained. Your Excellencies, the evidence that has been obtained in this case has been obtained through torture, and torture subjects a person to the submission of the person who is torturing them. And in the case before us, Your Excellency, the fact that Mr. Bandosa was tortured and was electrocuted is something that this court should take note of, that the statements that were obtained during that period might not have been were not voluntarily, and they might not be truthful and trustworthy as the prosecution stated. And to prove this further, Your Excellency, we would like to refer this court to the Nuremberg Trials, whereby evidence was obtained through torture was later found to be untruthful, considering the fact that the person who was tortured said something to stop the torture from going on. And a man by the name Jap Aschenbrenner, forgive my uncultured tongue, was tortured into signing a document, a self-incriminating document, stating that during the World Wars he was working in the gas chambers. However, years later, he was able to prove that during the period of the war, Jap Aschenbrenner was actually a student. Your Excellency, the prosecution also stated that the statement of facts, one way or another, allude that despite the fact that the evidence was obtained through torture, that the statement of facts corroborate this evidence because they state that Adjutant Bandosa conducted.
So would you state that the evidence obtained by torture does not even meet the evidentiary threshold at the moment that we need for a confirmation of charges? Is that your point?
Please come up again, Your Excellency. Sorry.
We are now at the confirmation of charges stage of the proceedings, and there we have a little bit lower evidentiary threshold that we would have to convict a person. So is it your statement, your point, your opinion that the evidence obtained by torture does not even meet this evidentiary threshold? That would be my question.
Thank you, Your Excellency. The defense is not looking at whether this evidence meets the evidentiary requirement. However, the defense is simply stating that the admission of this evidence in confirming the charges might be very unreliable because we are not even sure of the source of this evidence. Therefore, the defense or this court cannot be sure of whether the people who really tortured Adjutant Bandosa were working with the prosecution. And to top it up, Your Excellency, Article 21(2) of the Rome Statute provides for interpretation of the Rome Statute in accordance with international law.
Thank you. This is indeed an answer, so please continue.
Thank you, Your Excellency. And finally, in the interest of time, I'd like to show that the admission of evidence that has been obtained through torture would damage the integrity of these proceedings because this court would be admitting evidence that has been obtained through a violation of this court's statute, and this court would be acting in contravention with a norm of jus cogens. If this court is of no further use to me, I'd like to yield floor to my co-counsel. Thank you.
Mr. President, Your Excellencies, may it please this honorable court, my name is Lisa Winokur, co-counsel to the defense, and I shall use the remaining minutes to submit on the charges that the prosecution brings against my client. In seeking to convince this court to decline the charges against my client, the defense tenders the following arguments. First, that there were no crimes against humanity in FRN, as the chapeau requirement of an attack directed against a civilian population has not been fulfilled. Second, that there could be no enforced disappearances, as the actions of Pantera did not amount to abductions but kidnappings. Third, that there was no armed conflict. As to the specifics of the war crimes, that for the war crime of intentionally directing attacks against a civilian population, 2 of the 5 core elements as set out in the elements of crimes have not been met, specifically intention and object. And lastly, that Mr. Naberi's conduct in sharing photos of dead bodies on social media did not cause humiliation so severe as to be recognized as an outrage. If the court has no reservations, I would like to start my substantive submissions. Article 7.1 states that, or elucidates the chapeau requirements that must be met for a crime against humanity to exist, and this include, as rightly stated, a widespread or systematic nature of the attack against a civilian population in furtherance of a state or organizational policy. The defense submits that there was no attack directed against a civilian population in furtherance of an organizational policy. In Prosecutor Jean-Pierre Bemba, at the decision on the confirmation of charges, it was stated that an attack directed against a civilian population in the context of crimes against humanity must ensure or must fulfill that the primary objects of the attack are civilians. The defense submits that in the case of FRN, or in the violence that occurred in FRN, the civilians were not the primary object of the attack. And as to specifics of the enforced disappearance charge, that the drug barons, as stated by the prosecutor, were not even civilians. If there cannot be an attack directed against, if the drug barons were not civilians, there cannot be an attack directed against a civilian population. Further, the elements of crime state that...
How does that follow? If there's an attack directed against a civilian population, and in order to fulfill the plan of the government to rid itself of the pestilence of a drug organization, would it not be possible to disappear the drug barons in the context of that attack and still fulfill the actus reus of the crime?
Yes, Your Excellency, and the defense acknowledges this, this chapeau requirements work in a wider context, but the defense still maintains that first, there was no attack against a civilian population, and second, that there was no state or organizational policy that promoted an attack against a civilian population. As to the state or organizational policy, the elements of crimes state that the state or organization must actively encourage or promote an attack against a civilian population. The defense admits that in this case, first, the state did not encourage any such attack, as is stated in paragraph 3, of the statement of facts in the first page. Mr. Naberi presented the new government drafts of a new national security strategy, in particular on the elimination of the drug cartels. The defense admits that this shows the state's policy was not to attack civilians in the territories of the drug cartel bases, but to remove the purge that the drug cartels had instituted or inflicted on the territories of FRN. As to the specific requirements of enforced disappearances, the elements of crimes and also Article 7.2i define an enforced disappearance as an arrest, abduction, or detention, followed by a refusal to acknowledge such arrest or where the whereabouts are kept secret, with the acquiescence or support of a state, with the intention to remove them from the protection of the law. The defense submits that as per the facts, paragraph 4, it is stated in the line starting, while the agents of the Panthera in covert operations kidnapped the drug barons of the cartels. The defense submits that there were no abductions but kidnappings. In this respect, the defense forwards the preparatory works of the Rome Statute, where the state parties discussed whether to include the term kidnappings but decided to leave kidnappings to the realm of national law. Further, it is stated by Otto Triftera in his commentary on the Rome Statute that one of the reasons for this was the intention requirement for abduction and arrests and detentions in the case of enforced disappearances versus the intention in kidnappings are different. The intention as seen by the elements of crimes in arrests or in abductions are to remove from the protection of the law, but kidnappings can be done with the intention to gain a financial gain or for political gain. It is stated in the facts, paragraph 4, that the line starting with cartels, in order to prevent the opportunity for corruption and information leaks, as well as to destabilize the cartel's networking, the whereabouts of the kidnapped dragons were kept secret. The defense submits that this indeed shows an intention under the realm of kidnapping and not an intention to remove from the protection of the law. As to the specifics of the war crimes, or rather as to war crimes in general, war crimes can only be committed within the context of an armed conflict. The defense submits that there was no armed conflict, as first, the violence was not protracted as foreseen by the definition set out in Prosecutor v. Dusko-Tadic, and second, that the level of organization of the paramilitary wings of the drug cartels has not met a minimum level of organization. Now, in defining an armed conflict, Prosecutor v. Dusko-Tadic at paragraph 70 on the decision on the interlocutory motion of the defense stated that an armed conflict is resort to armed force between states, or more relevant to our case, protracted armed violence between a state's armed forces and an organized armed group, or between such groups within the state. Prosecutor v. Tadic went on and even was reiterated in Prosecutor v. Bemba to state that for an organized armed group to be a party to the conflict, it must attain a minimum level of organization. Further, Prosecutor v. Bemba, the decision on the confirmation of charges, also stated that the armed conflict or the violence must surpass a minimum level of intensity of internal disturbances, riots, or acts of sporadic violence. The defense submits that in the first place, the violence in FRN was not protracted. If I may direct the court.
But it continued for approximately 6 months, the attacks on the drug cartels, and in respect of organization, the facts do in fact suggest that the FRN was mostly known as the birthplace of hierarchically well-organized drug cartels. So it's an accepted fact that the drug cartels were well organized. The only question is whether the 20 drug cartels that were subjected to the attack were organized under one umbrella, or they were well organized individually in their separate areas of drug distribution.
First, Your Excellency, the defense does acknowledge the statement that is set out in the facts, but we maintain that the drug cartels or the paramilitary wings of the drug cartels have not attained a minimum level of organization, as they lack the ability to carry out sustained military operations. As to whether the 20 drug cartels actually fell under one umbrella, the defense submits that because there is no available evidence to show the same, this cannot be as presumed from the facts. If I may refer to the situation in Mexico, a very tense situation, the president of Mexico has stated that there is no armed conflict between the drug cartels and the armed forces of Mexico, due to the fact that the drug cartels in Mexico are under different umbrellas and are not one conglomerate, so to speak, working against the state's armed forces. As to the organization, the defense acknowledges that ability to carry out sustained military operations is a chapeau set out in Article 1, Additional Protocol 2, and this is not such a conflict. However, the defense states that even in cases where this court was analyzing a Tadic, if I may frame it that way, a Tadic conflict, it has looked at the ability to carry out sustained military operations. Examples of such cases include Prosecutor v. Jermaine Katanga, Prosecutor v. Bemba, and Prosecutor v. Calixte Mbarushimana. In this respect, the defense contends that the fact that within 5 months, as stated in the beginning of paragraph 6, Mr. Naberi was able to eliminate, Mr. Naberi and the military was able to eliminate 15 out of 20 drug cartels, seize 150 metric tons of cocaine, seize 6,672 firearm units, points to the lack of ability or the incapacity of the drug cartels to actually carry out sustained conflict. Further, as per paragraph 4, it is stated that the fighting only lasted several days. The first sentence states that which led to, starting from the middle of the sentence, which led to heavy fighting with the paramilitary units of the different drug cartels, lasting several days in certain regions. This fact points to both the lack of protractedness of the conflict and the lack of the paramilitary wing's ability to carry out sustained military operations. As to the specifics of the war crimes, the prosecution charges my client with intentionally directing attacks against a civilian population. The defense submits that there isn't sufficient evidence to establish substantial grounds to believe that these attacks have been, or that this war crime has been committed, as the requisite intention has not been met by my client, and that the object of the attack was not a civilian population. First, as to the intention, the elements of crime state that the perpetrator must have an intention to direct an attack against a civilian population. In assessing this court has pronounced itself severally and stated that civilians must be the primary object, much like the chapeau in crimes against humanity, and not incidental victims to the attack. This was stated in Prosecutor v. Mbarushimana on the decision on the confirmation of charges, in Bemba also, and other cases that I shall forward to this court. The defense submits that there has been no evidence to show that my client had a specific intent to actually direct an attack against a civilian population. The chapeau, or the element of could have been aware or could reasonably have known, as forwarded by the prosecution, cannot apply in this case, as stated in Prosecutor v. Mbarushimana, decision on the confirmation of charges at paragraph 142. A specific intent or I want to cause the consequences is required. And it is clear that Mr. Naberi, my client, did not want to cause the consequences of death to civilians, but merely intended to direct an attack against a civilian population. As to the object of the attack, the defense submits that first, the object of the attack was, if I may have 1 minute to wrap up.
No, we conceded it to your colleague, so you also have 1 minute more.
Thank you. I am glad for the equality of arms that
equality of arms, fairness, like it is often quoted in these courtrooms, yes.
Thank you, Your Excellency. The defense submits that first, the object of the attack was the drug cartel basis, and second, that any damage to civilian property or loss of civilian life, while unfortunate, is collateral damage and could not have been so excessive as to show that my client had a dual intention to actually attack a civilian population and to attack the drug cartel bases. There can be, first, as to the excessiveness or whether excessive damage was caused, Prosecutor v. Jermaine Katanga actually laid out this dicta, but went on to state that they could not actually find beyond reasonable doubt that Jermaine Katanga directed an attack against a civilian population, as there was no available evidence to show that the damage to civilians was so excessive that it could show he has a dual intention. In the same strain, I submit that this is the case with my client. There is no evidence to show that loss of civilian life was excessive compared to the military advantage. The facts just state that 4,760 members of the cartels were killed. This has no bearing on whether these people were civilians or were not civilians. as I know I am out of time, unless this court has any questions or any clarifications.
No, I think you are indeed out of time now. So out of fairness to everybody here in the courtroom, I think we would just have to stop it here and now give for, again, 5 minutes the prosecution the floor.
Mr. President, Your Honors, may it please the Court. During the rebuttal, the prosecution would like to address several issues. Firstly, the admissibility issue. That is concerning the term which was in this specific case and its applicability in our situation. Secondly, the issue of the admissibility of evidence obtained through torture as raised by the defense counsel. And thirdly, several issues concerning the charges which are contested by the prosecution in this respect.
A big program that you have, so please start.
With regard to the first issue, the counsel for the defense have submitted that in this specific aspect, the complexity of the case led to the conclusion that 6 months' lack of investigation or other actions is not a sufficient ground to determine that there was an inaction on behalf of the state. However, we would like to refer the attention of this court to the Georgian situation, which was reviewed by this court, and where it was stated that if a state was not acting for 6 months after officially disconducted the investigation, that means the inaction and therefore the admissibility of the case before the ICC. Also, in respect of the second submission during the rebuttal, we would like to emphasize that the defense, while applying Article 69.7 of the Rome Statute, do not provide the reasoning why such actions, which were seen on the video provided by the unknown source on the internet, shall be regarded as torture. And we respectfully submit that if there is no proof that the evidence was allegedly violating internationally recognized human rights, provisions of Article 69.4 shall be applied, notwithstanding the subsequent submission of the defense. And finally, regarding the charges which are contested by the prosecution, we would like to address the issue that the direction of attack was not into the civilians. And in this respect, we would like to refer to the fact of the case and particularly to the statement from 12 December 2015, which was made by Mr. Naberry, where he stated that everybody who collaborates with the drug cartels is an enemy. And this point that Mr. Naberry intentionally directed attacks against civilians. Therefore, if there are no further questions, this concludes the rebuttal of the prosecution.
Thank you very much.
May it please the Court.
Could I just, before you go, just on that last point, the statement by Mr. Naberry is in the present tense, every person who collaborates or was even forced to collaborate with the drug cartels as our enemy. Isn't that a future-looking statement that they've ended the conflict, many people died, 15 of the drug cartels were successfully eliminated, and this is a warning to the remaining 5. Don't collaborate with drug cartels. That's one way of interpreting it, and you give it backward reach. I'm just wondering if it works based on the plain reading and the grammar of the statement.
Indeed, it may be true, Your Honor. However, the position of the prosecution in this concerning this specific statement is that Mr. Naberry, as a public official in that specific statement from 12 December 2015, regarded the actions which were already made by the military troops of Federal Republic of Nabu, and therefore it was an evidence of his intention that the civil population was also directly attacked by the military troops. Thank you for your attention.
Thank you, and I give now the floor again to the defense for a rejoinder.
Your Excellencies, it's nice to see you again. To reply to the points of rebuttal that the esteemed prosecutor has brought forward, first, he he alleges that the 6 months actually amount to inaction, or that the 6 months after the conclusion of the investigations amount to an inaction on the part of FRN, and actually states forwards the case of the situation in Georgia. First, in this respect, the defense submits that these 6 months cannot be considered in the context of inaction. If I may refer or direct the court's attention to Prosecutor Vijamain Katanga, decision on the admissibility of the case, it is stated that inaction cannot be considered without first that unwillingness or inability cannot be considered without first looking at whether there are investigations. So if the prosecution is alleging that there are investigations, then after there is an inaction, that cannot actually be, that does not fall within the definition of inaction as per the dicta of this court. If I may clarify the 6 months, that the 6 months the 6 months being referred to by the prosecution were after the conclusion of a legitimate investigation as established by my esteemed co-counsel. Therefore, the prosecutor should actually be forwarding arguments on whether these 6 months were an unjustified delay and not whether they amounted to inaction. As to the second point on the evidence, on whether the evidence admitted before this court on whether the evidence admitted before this court amounts to torture, the defense submits that first, above everything, the case facts at paragraph 7 state that a short video was published on social networks by an unknown source capturing the torture of Adjutant Bandosa, who was being asked to reveal the locations of the kidnapped drug barons. After several beatings and parishes, electrical torture known from Latin America, he made the statements that he did. Further, Article 7.2 of this statute defines torture as, and if I may quote the exact definition, torture means the intentional infliction of severe pain or suffering, whether physical or mental, upon a person in the custody or under the control of the accused, except that torture shall not include pain or suffering arising only from lawful sanctions. The former part of the definition is very relevant to this case, as clearly the the kidnappers or the torturers of Mr. Bandosa had him within their control first, and intentionally inflicted severe pain or suffering from the several beatings that he received, and the electrical torture that he was also inflicted. Further, the fact that the unknown sources wanted to find out the location of the kidnapped drug barons shows that they actually intended to inflict pain in order to extract information from Adjutant Bandosa. Therefore, the prosecution finds the defense states that there is no factual basis to find that the actions in the video do not result to torture. As to the last point on rebuttal, which is that Mr. Nabedi intentionally attacked civilians based on the case facts, at paragraph 2, where it states that the territories where the drug cartel bases were, where the drug cartels were based, included farmers and countrymen, the defense acknowledges that under the ICRC guidelines on direct participation in hostilities, that these civilians who are only involved in the manufacturing of drugs, armory, and other technical supplies would not be considered as direct participants. However, the defense submits that first, these guidelines have not acquired customary international law status, as stated in Prosecutor v. Abu Garda, the decision on the confirmation of charges, and second, that this court should consider that the actions of manufacturing drugs and armory actually contribute or have a legitimate contribution towards the war effort, so to speak. If the court has no further reservations or questions, I beg to rest my case.
Thank you very much. I thank both parties for their submissions. This concludes the hearing of the submissions. The bench will retire for deliberations and will not let you wait long. Now comes the difficult part for the bench. We all have heard what has been said in the past 1.5 hours, and I think we were all deeply impressed by what has been said by both teams. We had 2 excellent teams. We had witty speakers, charming speakers, quick speakers. Both teams and all speakers directed their submissions to the bench, tried to engage with the bench, entertain a sort of conversation with the bench where we did not have enough time to really do that. They made eye contact, which is very good, because it's always important for counsel to really know whom they have to address in a courtroom, who are the ones who decide. And I also understand that I came a little bit late, but I have heard that you have gone through a marathon today. I think, I don't know how many times you have not only repeated, but have to go through the same arguments over and over again. So this is also, I think, a heavy burden that has been put on you. But nevertheless, of course, we had to decide, and we have decided that there was a slight advantage of the Kenyan team. So the winner is the team from Kenya. I will... It's difficult to reason that, but of course we have reasons, and I provide them to you. You referred, I think, very exactly to the case law of the ICC. This impressed us a lot. I have also been told by my 2 colleagues that they have heard you before, once.
Very early.
Also very early, and they said they were also impressed how you improved in the last 2 or 3 days, and that is not the decisive moment, but I've been informed of that. The referral to the cases was impressive. It was exactly like you would want it as a judge. It was with reference numbers, it was with paragraph numbers, so it really would help a bench, the judges in the deliberation room, to decide in the end. And we also thought there was a slight advantage when you referred to the facts of the case. So this is the reason, but this, of course, are very minor advantages, but in the end we have to decide, and we decided that the best team is indeed Kenya, and this concludes our short reasoning of the decision. Thank you. We'll come shortly back, I think, with the awards that have been to give to the teams and to the best speaker and
second best speaker.
And second best speaker. See you soon.